So one of the big factors when determining liability on a property owner in a premise liability case is you have to prove that they either knew or should have known that the defect existed. And obviously it's difficult to prove what someone knows because we can't go into their head and see what they were thinking at the time of the accident. So there's a couple ways that we can go about proving whether they had knowledge or not. First, we can look at communications that they may have. So say if there's some defect with the property or an issue that someone notified them about, that's a way for us to prove that they were aware of the issue. So that can be in the form of a text message or a letter or an email making someone aware. Otherwise, if there's no direct proof of their knowledge, we can also prove that they should have known because of how long the defect existed. So obviously it's difficult to prove that they knew that something was wrong if, say, there was a spill on the ground that had only been there for a few seconds before an injury happened. But if there's a spill or a defect that had existed for a long enough period of time, they can't claim that they didn't know it happened because it had been there for so long, essentially, where the issue exists for long enough that they should have known. One other way that we can prove that there was knowledge too is if there's other, work orders or documentation from third-party companies to correct the issue that maybe didn't fully fix what the problem was. So it can depend on the specific case and what sort of defect we're looking at. Those are a few examples of things that we look for in these premise liability cases.